everyone. Welcome to the September 14th, 2017 Public Service Commission meeting. The first thing on the calendar is the reading of the meeting minutes of August 22nd, 2017. Does anyone have any corrections, additions, changes to the proposed meeting minutes? If not, could we have a motion to approve them, please?
We approve the minutes of August 22nd as presented.
I second it.
Any discussion? Hearing none, all in favor signify by saying aye. Aye.
Aye.
Any opposed? Any abstentions? The motion carries. The consent agenda is 2 items on it. Does any commissioner wish to have one of them taken off the consent agenda and placed on the regular agenda?
Move that we adopt the consent agenda as presented.
Second.
Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any
Mr. Chair, may I have 1 minute, please, to say something?
Can we just finish?
Okay, go ahead.
Any
I thought we
noes? Any abstentions? Commissioner Conaway.
I would just like to take this opportunity to thank our utility workers. Everybody thinks of the fire and the police, and they are indeed risk their lives, but so do our utility workers, and we sent quite a few down to Florida, and I appreciate that very much. Thank you.
There are actually utility workers from Alaska and Florida as
Yes.
we speak.
Yes.
Mr.
All
Chair,
over.
I'd also like, just if you would bear 10 seconds, I'd like to recognize and acknowledge the passing of Arnetta McCoy.
Oh, yes.
Who was the former chair of the commission, and everywhere in the states that I go, people ask me about her and how she's doing. I attended her ceremonies about a week ago. I saw Mr. Delaware also was there, probably other folks related to the commission. So we appreciate her service, and I just wanted to acknowledge her.
Thank you, Harold.
Thank you, Commissioner Gray. We all liked Arnetta very much, and she was basically my mentor, so she meant a lot to me, and I owe her a lot. So. Okay, the number one item on the regular, I was going to ask if a traffic jam were extraordinary, it was an extraordinary reason for being late to a commission meeting, but I'm sure it probably is, right, Mr. Howard?
Yes.
It is.
It was definitely a challenge out there.
Yeah.
Everybody else got fun.
I would say
I thought everybody else was here, so I was just wondering if I was the only one.
No, a lot of us were. I was delayed first thing in the morning, and everyone was delayed. So, unfortunately, Del Dot is not in our meeting today. So, number one is in the matter of the formal complaint of Emblem Associates LLC against Artesian Water Company regarding a contribution in aid of construction dispute. Welcome, Mr. Spate, Mr. Randall.
Good afternoon.
This is the state's report, so I believe we have, since I've picked up the wrong agenda, don't have the names on it. Is this Mr. Willard?
No, this is Mr. Walsh.
Mr. Walsh.
Thank you, Chair Winslow and Commissioners. This report actually has been summarized by Ms. McDowell, and with the Commissioner's permission, I would ask that she be allowed to give an update. So,
There she is. Oh, that's where she is.
her workshop.
Okay. Ms. McDowell, please.
Yes, my name is Dale on behalf of PSC staff. In PSC order number 938, the Commission directed staff to conduct a public workshop for the limited purpose of considering whether our admin code should be amended to require additional notice of communication from utilities with respect to SIAC costs. So on May 11th, 2017, I conducted a public workshop here in the Commission hearing room. Several parties were in attendance besides staff. There was the DPA, Tidewater, Artesian, Suez, Ashburn Homes, the Home Builders Association, the Delaware Association of Realtors, Leon and Jr. and Associates, Ocean Atlantic Companies, Committee of 100, Newcastle County Department of Land Use, Sussex Shores Water Company, and the law firm Drinkle Biddle I opened up the floor for comments, and I took a lot of comments and they were transcribed. Just to summarize in the end what my conclusions were, I didn't get any really good suggestions of how to solve this dilemma. But in researching, I found that the Office of Drinking Water has the developer or home builder, when they want to attach to the water company, they have to get approval to construct. And with this approval that they get, a copy is sent to our water utilities. So I recommend that the water utilities then send a letter to the developer or home builder informing them about that they possibly could have SIAC costs, and that each should keep in communication with each other for any updates or delays, so that full information is given. I don't think that the regulations necessarily have to be reopened. I think that the commission can issue an order with that recommendation. There are several parties here. I'm sure they would like to comment.
Thank you, Ms. McDowell. Who wishes to make comment? Mr. Randall?
Good afternoon. Actually, Mr. Spate will speak on behalf of Artesian on this matter.
You want to introduce him?
We agree with staff's recommendations here in this matter and the findings that she made at the workshop. Reg Docket 15 has been around since 1986. This is possibly the first complaint that we've heard arise from the regulations set then. Quite frankly, the requirement for SIAC and advances has been around forever, as far as I know, for offsetting costs associated with the development of systems in water systems specifically. A lot of the workshop centered around other matters other than communications. We know that it's difficult to prescribe communications between parties. It's generally just good business practices. This discussion is, however, about communications. And we believe that we should have done a better job in communicating often with our development community, and we do on most occasions. Does this matter, or should this matter, lead to regulations requiring companies on both sides to do what it normally should have done out of good practices? No. For several reasons. The PSC can only regulate one side of this equation, and that's us. That's Artesian Water. That's the other companies involved in this matter. Building requirements also differ across the different counties. There's 3 counties, and each of them have different building code, different requirements, and different regulations, so different communications required. However, communications is always required in good business. As presented by the developers in this case, however, if there are regulations regarding communications and there is a miss in communications, the resulting risk is laid with either the company or its customers regarding the payment or the recovery of payment for infrastructure installed. We don't believe this is a good result. Since the developer is not required or regulated, there is no consequence for their lack of communication. We believe that in the end, good business practices demand good communications. And we believe that in overwhelming circumstances, those communications have been accomplished. And we believe that no further regulation is required with regard to Reg Docket 15. Thank you.
Thank you, Mr. Spade. Ms. Iori? Are there other parties that wish to comment on this docket? If so, would you kindly come to the table and make yourself comfortable and state your name and your business for the record?
Certainly. Thank you, Mr. Chairman. My name is Kevin Kelly. I'm managing principal of Leon Wiener and Associates, Inc. Leon Wiener and Associates, Inc. Is the entity that controls Emblem Associates, which filed the complaint in this instance. I will say that I am pleased to hear the support by Artesian of this recommendation. I don't understand why it wouldn't be memorialized in the docket itself. But I'm not familiar with your processes and procedures. I certainly am in many other instances. I do a lot of affordable housing that involves state, federal, and local governments. Their regulations are typically very explicit and very clear and can be pointed to if and when there is a situation of dispute and debate. So I'm not sure. I don't understand that component of the process here. I will admit that. But I do applaud the recommendation of staff. I think it is prudent public policy and prudent practice to ensure that the parties are communicated with. This goes beyond me. I clearly made a mistake in this instance. I relied, and as was testified to in the workshop, so did the vast majority of those who testified that day, relied on the wording in the Unified Development Code as the guide for the practices we undertook. You heard from the Society of Civil Engineers. You heard from Mr. Tucker, the former attorney for the county when the UDC was developed. You heard from Mr. Haggerty, the acting assistant land use manager, that it is the perception. It has been the perception. It has been the understanding that that rule guaranteed developers such as myself a 5-year window. The reason I didn't communicate is I had the 5-year window. Communication didn't go as long as Artesian would have would stated in the record, and that's demonstrable. But the fact of the matter is there is a conflict there. I think it behooves the commission and the county, but that's up to you, to try and rectify that. But again, I would support the recommendation, but ensure that it is an enforceable recommendation that has remedies if the parties don't follow it. I would also suggest, as many of you own and operate your own businesses, certainty is a hallmark, an underpinning of operating a successful business. Predictability and certainty, and I would suggest that this regulation, rule, whatever it is, have very definitive requirements as to the obligation of the parties affected by it. That creates a sense of certainty, and will avoid the circumstances I found myself in. I had no interest in spending $300,000 in legal fees to bring this case. I felt I was aggrieved. The hearing examiner felt that the process clearly was lacking, and that's what brought us here today. So thank you, Mr. Chairman.
Thank you, Mr. Kelly. Is there anyone else present who wishes to speak? Just come up one at a time, and if you would, once again, state your name for the record and the name of your business, who you're representing. Welcome.
Hi, thank you. Good afternoon. Thank you. My name is Howard Fortunato. I am the Executive Vice President of the Home Builders Association of Delaware. I was also here at the May 11th workshop. I would also, and I'm speaking on behalf of our membership, builders, associate members, subcontractors, suppliers, etc. I would also like to concur that I support and I appreciate the recommendations of the staff for the notice, for the reasons that Mr. Kelly has enumerated. The one thing I have the staff's order here, PSC staff report, and the only fine point I want to point out is that they recommend that it says staff recommends that the water utility be required to send a letter to the developer informing it that Category 1B CIA costs may be required for water service. And these costs can change. And the only thing I wanted to point out is that in and of itself, in the way that's written, it would seem to me that could be a blanket standard letter, and I think it would be tweaked and improved a little bit if it, that it was it was used in the case when the utility knows, in fact, that there will be CIAC costs, and once they're determined that you will have costs, and we think they're going to be X thousands of dollars. And I think generally, other than that, I don't have a lot of things. In closing, I would agree. Certainly, the communication is important, and on behalf of the Home Builders Association of Delaware, I would certainly volunteer as a volunteer aspect to help communications that as any water company or any of the utilities find that they have these, we'd be happy to get the word out and communicate that to our members. I'll facilitate that. We don't want to be, I'm not looking to be an intermediate, but at least get the word out and get the parties talking. So,
That would be a good thing. Thank you, Mr. Fortunato.
Thank you.
Welcome.
Good afternoon, Mr. Winslow, members of the commission. My name is Ted Williams. I am president of Landmark Science and Engineering in Newcastle. We're a civil engineering firm that provides engineering, science, environmental services. We were actually involved in the Emblem project. But first I wanted to do two things. One is I want to commend the staff on a thorough hearing that we had when we had the initial case we brought forward. I was not able to attend the May 11th public hearing, but I did provide a written statement, and I appreciate you recognizing reading that in the record. I also agree with Mr. Spake that the communication was probably something that was on both sides, and I appreciate his comments on that. What I'd like to recommend to the commission is that if you're not going to put this into the actual docket, but it's going to be a recommendation from this report, I'd highly recommend you to contact the Newcastle County Department of Land Use, at least in particular in that situation, and try to have a better coordination that they can make adjustments in their Unified Development Code that provides some guidance not only to the engineering firms but to the developers so that this situation doesn't arise in the future. In Newcastle County, when a plan is recorded, it's valid for 5 years. And you can also get an extension of that for another 5 years if you make a request. And we all know that the economic times, things change. We see upturns and downturns, and when you have a downturn, a plan might be recorded but not proceed forward. So maybe some things, language added to the UDC that would require some additional communication with the utility companies to make sure something hasn't changed. That would help the developers know before they proceed forward. Because as Mr. Kelly said, and we do this a lot with our clients, we do diligence studies all the time. We reach out to Artesian. Artesian staff is excellent. They will tell us exactly what their plans are, if anything's available, and let us know if there's going to be improvements. Because our clients are looking for us to tell them, is it going to be possible then to develop a project? And what are the cost implications to them? Is it going to be road improvements? We get that information as much as possible from DelDOT. Is there going to be a sewer extension? Newcastle County can provide that. Do we need to extend a water main to the site? Or is there one existing, but it might need to be improvement? We can get that from Artesian. And we give that to them at that stage when they are starting their development. But when the plan's recorded, we are all under the assumption that everything we've been found before is there. All the approvals have been in place. We've even, in some cases, gotten approval from Artesian or Tidewater or Suez to construct the water, but we've not moved forward. So I'd recommend the commission reach out to Newcastle County, the County Levy Court, Sussex County Department of Planning, even the municipalities that have their own processes, to make sure that a situation like this doesn't occur in the future. And if there is plans, they have to reach out to their utility companies if they're going to get an extension of those plans. So that way, everybody's aware of a potential change, a potential kayak charge. I think most of the developers will tell you that if they know up front about this, they can put that in their pro forma and they know they're going to have to make these types of improvements. But if the water main is there and the capacity is there, they might not know that until Artesian, Tidewaters, whoever makes that recommendation to them. So I'd recommend that to the commission, and I thank you for allowing me to speak today.
Thank you, Mr. Williams, for your input. It's much appreciated. I guess you're probably a Boston Red Sox fan, right?
My father was a Boston Red Sox fan. I'm a Cleveland Indians fan. So.
Living well.
Yes. When I grew up in Ohio, I've been a Delawarean now pushing 40 years, so I think I'm a native anymore. But I grew up in Ohio, so that's the reason why I'm a Cleveland fan. But thank you very much.
Thank you, sir. Somebody else would like to speak? Okay. Any commissioners have any questions or any comments to make? Commissioner Drexler?
My only comment is I do appreciate the staff report and the steps that are being recommended. I just think it's a little bit vague in the requirement that the cost may change, which, I mean, I read that to mean increase. If there are delays in project construction, it says to me that's the only reason, that there could be a change in the cost, and that may not be what is the intent of the recommendation. And I just want to know what the comments are on that.
Sure. In the infant case, it was 5 years between the initial time that they put in that they wanted to construct that development and when they actually it came to be. In the last part of the development, they changed to apartments that required different criteria from the state fire marshal's office. So the actual pipes that needed to be in had to be increased, not only for them to meet the requirement, but the mall had some other additional construction they wanted to make. So from year one, they may not have had additional SIAC costs to actually put their development in. But by year 5, there was necessary improvements that had to be made that the different developments needed to pay for.
So it's not specific, but so what you're saying is it's not only delays in project construction, but changes in the actual development plans.
True. That's true.
Mr. Chairman, may I, please?
Yes, sir.
I regret that I continue to hear this from Ms. McDowell. I stated very emphatically at the workshop that the plan that went in and the plan that has been built is identical. The plan that was submitted to Newcastle County, submitted to Artesian Water in 2010, was identical to the plan that was built. There were no changes. The land I had controlled for a long time. Prior to 2010, there were. But in this situation, and I have stated it repeatedly, the county has confirmed it repeatedly, that plan did not change. And I am troubled by the fact that we continue to go to this subject where the record is emphatic and clear that the plan did not change. And so as to the 5-year delay, it happened to be 2010 when I filed the plan with the county. It was September 2011 when that record plan was approved. I am glad to say I've completed the project recently. They were identical. So I'm very troubled by that continued misstatement. Also, as regards the 5 years, my fault, no question about it. There was an intervening thing called the Great Recession, the worst downturn in real estate except for the Great Depression. Not a prudent time to advance a plan when unemployment was skyrocketing in the county, when economic circumstances were as terrible as they were. That's my fault. That's my problem. That's what I do. I'm a developer. But I continue to be troubled by this, and it is obviously a source of annoyance that this continues to be repeated and is a distortion of the fact.
Mr. Chair.
1 second, Commissioner Gray. I appreciate your concern, but I believe that what Commissioner Drexler is trying to get to is really more specific language to give notice to the owners and to the, from the water company. I don't think we've intended to get into this. I'm sure that Ms. McDowell perhaps misspoke, but we're really just we're agreeing with you that you should get more notice. I think what she's trying to do is make sure that that's more comprehensive, more specific, and gives you more information. So I think that's really the issue at our discussion here.
And I would appreciate that, but again, I've heard this repeatedly, and it's very disconcerting to me.
Oh, I accept I accept what you said at exactly the way you said it, and I accept that as the gospel. But now, if you don't mind, if we can work toward the end of this, which is getting the correct language in the order so that the commission does its job of notifying land use and other people, and hopefully Mr. Fortunato will use his organization and send the same communications out, and hopefully the home builders, will do their work, and then at the end of the day, we won't be sitting here in the next 10 years having this discussion again, because everyone will know what's expected of them when construction goes on.
I appreciate it. Thank you, Mr. Chairman.
Thank you, Mr. Keller. Commissioner Gray.
Well, thank you, Mr. Chair. I was trying to conceptualize what Commissioner Drexler may have had in mind, and the language reads now, these costs may change if there are delays in the project construction. If one were to add or in the project scope, does that become perhaps a little more comprehensive? Because scope can be measured in a number of different parameters.
Yes.
And so can delay. Yeah, that would just maybe.
Mr. Spade, will you have any comment with respect to the proposed changes in the language?
I do. And it really is because of the certain circumstances, but it can be broadened. There are circumstances where, because of delay of time, the circumstances of the general area require certain infrastructure that is more akin to the whole rather than to the specific as it's being built. In this case, this was a finite area within the system that could only be serviced in one way in order to assure quality supply, but there was other infrastructure necessary to increase capacity outside that system. So it was a one joint project that was done. All right. So it's not just the circumstances or scope of an individual project that we have to be prepared to address. It's the scope of the area in which a certain supply source and or infrastructure is necessary to maintain and continued quality service. And that's kind of the difference. When you said scope, it may be construed to me the scope of the project. In this case, his scope didn't change. It was simply a matter of the scope in the general area had changed that required a secondary feed to this area, of which they were part of the cost causer, and that's what gave rise to the Schedule 1B charges.
I apologize to tag team here, but it also occurs to me that there are instances where costs can increase because of difficulties that are incurred in the project. If you have a directional bore and there's a blowout, it's going to be a more expensive project than you envisioned. It might be simpler and safer to simply end the sentence at the costs are subject to change.
Yeah.
Ms. Iori?
I just had a question based on, and if that's what the commission is going to do, then it takes care of my question. But when Mr. Spade was speaking, he was talking about changes in the scope that were more from the utilities perspective versus the builder's perspective. Because as you said, their plan never changed, but it changed for Artesian because of intervening things. So if the commission is going to end it at costs may change, I think that takes care of it. But if the commission is going to be more specific, it seems to me that it kind of throws a monkey wrench into, I mean, I'm just thinking out loud, which is dangerous.
Yeah, when she's finished.
She just warned us, and you're free to go.
Okay. My preference would be to end it in that costs may change, because if we start delineating this, we're going to miss something, and then that's going to come back to haunt us.
I agree.
Okay.
My thinking also.
Okay. Any other questions by the commissioners? Somebody want to make a motion? Commissioner Drexler?
Is there an order?
No.
No. There's no order here.
Well, there's got to be something that we have to have the basis of the order as a motion.
We have to ask the staff to
I make a motion that the staff prepare an order outlining the steps that are provided in the report, the approval to construct from the Office of Drinking Water. The Office of Drinking Water sends a letter to the water utility. The water utility is required to send a letter to the developers regarding Category 1B SIAT costs, and to end that sentence with costs may change.
May I make a friendly amendment that the commission, pursuant to the advice given to us, I believe, by Mr. Fortunato, that the Mr. Williams, was it Mr. Williams?
Mr.
Mr. Williams, I'm sorry, that the Public Service Commission write the Land Use Department of Newcastle County and also Kent County and Sussex County, advising them of this issue and requesting appropriate changes in their respective planning documents so that notice is given to contractors, general contractors regarding perhaps unexpected utility costs.
I second.
Is that accepted by the?
Yes.
Okay.
Yes.
Is there any, is that a second?
Yes.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion carries. Thanks very much. Mr. Fortunato, Mr. Williams, Mr. Kelly, obviously. Okay, the next item is number 2 in the matter of the application of Delaware Power and Light Company for an increase in electric base rates and miscellaneous tariff changes. And we're going to consider proposal order 9083. And I guess Mr. Geddes?
I can start, Mr. Chairman, members of the commission. Hopefully you have before you a third iteration of these orders, which was drafted last night and sent out. I believe, Ms. McDowell, the commissioners have a copy of this. Yes?
Yes.
Okay.
Yeah.
Just to go over it briefly, the difference between the prior orders that you saw with respect to staff's proposed version, that has been modified, and the issue restatement has been taken out and joined with the other sentence. And so it reads that the commission on the record presented here does not affirm the hearing examiner's ruling on the evidentiary issue raised by staff's exceptions, and we are not reaching a decision on whether the hearing examiner's ruling was correct or not. Accordingly, we do not adopt footnote 6 on page 20 of the report, and it shall have no precedential value in future cases. You'll recall that in July 25, when we were last together on this particular docket and these issues, two commissioners, Commissioner Gray and Commissioner Drexler, made comments with regard to their desires with regard to additional draft of this order. I believe that this accomplishes what they were seeking, hopefully, but obviously I'll leave it up to the commission whether they think it's appropriate to sign this version of the order. Thank you.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Chair Winslow and Commissioners. Public advocate and staff worked together on to get to where that order is. Hopefully, it does reflect what the commission did with the concerns that the DPA had. And hopefully the commission will approve it. If not, I guess we are back to the drawing board.
I don't think we want that.
Just to,
You don't want that.
excuse me, when she's finished, just to encourage you, I do have a copy of Bleak House, written by Charles Dickens. You recall on 25th, I cited an Englishman of the 20th century, man of the year, man of the century. This is another Englishman who was also a good writer, and referred to the case of Jarndyce versus Jarndyce. I will get you the spelling, because it's not spelled the way it sounds, which every lawyer in this room knows. It's an Old English case, and it ends, and it's just a short paragraph. If you would like me to read it to you, I think it's appropriate. This is about an estate, and of course it's about lawyers. The estate was very extensive, and after 40 years of litigation, there was no estate. But and of course Dickens is going after the court system and Chancery Court in particular in the 1850s. And specifically, no one could remember what the case was about. And so on page 832, he stated, this character, we asked a gentleman by us, and it is stilted English, so I'm not mispronouncing it, although I am a stutterer, but I'm doing my best. We asked a gentleman by us if he knew what cause was on. He told us Jarndyce and Jarndyce. They didn't use verses back then. We asked him if he knew what was doing in it. He said, really, no, he did not. Nobody ever did. But as well as he could make out, it was over. Over for the day? We asked him. No, he said, over for good. Over for good, exclamation point. I think it's appropriate in this particular case.
I would like to point out that the lawyers obviously had sizable estates.
The difference being that at least one of the lawyers in this does remember what it was about.
Maybe two lawyers.
Mr. Goodman, I'm sorry.
Didn't want to speak for you.
Your Honor, I'm a dad. I'm only up here because it was Delmarva's case to start with. But I have no idea where it's gone since she gave a final order several months ago. I'm confused as to what's going on.
Thank you. Thank you, Mr. Goodman. Any commissioners have any questions of the parties?
Mr. Chair and Mr. Geddes, I'm probably on page 830. You were reading from 832, so I'm getting pretty close to not remembering what the case was about. I do see two orders with the same number, so I just need some clarification which lane we're driving.
This is
One is the DPA's and one's ours.
There were three, but this is the newest, latest, and greatest.
One without an
yeah,
adverb in it,
yeah.
and a shorter paragraph one, which Chancellor Quillen always said, if I had more time, the order would be shorter, or the opinion would be shorter. It's a shorter paragraph one.
Yeah.
And it's really good. I mean, the final is so much better than the other two. It's just so good.
Can I start back on page one?
Yeah.
Just give Commissioner Gray a moment.
Thank you. Mr. Chair, I would recommend that the Commission adopt order number 9083 as submitted.
I second.
Is there any discussion on the motion to approve the order? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you all. I guess we're at number 3 at this point in time. In a matter of integrated resource planning for the provision of standard office service by Delmarva Power and Light Company. Ms. Scott? We feel confident that you know exactly what this is about.
Commissioners. This is the form of order to ratify the 2016 IRP. As you are aware, Delmarva is required by statute to submit an integrated resource plan every 2 years. And as we have done in past years, once it has been prepared, we have a working group meeting with those parties that have an interest. and have dialogue about what's in the IRP, what needs to be addressed, what should be addressed in the next IRP, which we did in this particular instance. And the parties then proceeded to submit their comments to the hearing examiner, who prepared his report recommending that the IRP be ratified because it meets the requirements of the statute and the regulations.
Thank you, Ms. Scott. Mr. Willard?
Yes, we agree that the IRP meets the standards. Staff did have several comments and recommendations for future IRPs, and my understanding is DPNL has agreed to talk about that before the next IRP with all interested parties, and so there could be some changes based on those recommendations. But staff does, in fact, agree that at this point the IRP should be approved. And Mr. Nielsen is here if there's any questions.
Thank you, Mr. Willard. Now, Ms. Iori, you'd probably like to put this issue in the same bed as jaundice versus jaundice, right?
Actually, this is not quite as bad. We do have another jaundice versus jaundice coming up, but I'll leave that for later. I think the Commission knows how the DPA feels about IRPs. The DPA was pleased that staff has suggested perhaps legislation to change the requirements for it, and we would wholly support and would work with staff if they do continue to go that route. But insofar as the issue before you, which is whether the IRP should be ratified and the docket should be closed, DPA says yes. Thank you.
Thank you, Ms. Iori. Mr. Noyes.
Thank you, Mr. Chair. Our lawyer is stuck in traffic. So maybe that'll move things along, but we don't have a great deal to say except that we support the proposed order and recommend its adoption. There are issues to be addressed in developing the next IRP, and DENREC is committed to working with Delmarva and the other parties to craft an IRP that is focused on the issues that we all think are most important to us. Thank you.
Thank you, sir. Mr. Burkett.
Yes, thank you, Chairman Winslow and Commissioners. I'm before my favorite commission in the region, which so I'm glad to be before you. We do support the order. We think it's appropriate in this case. One suggestion that we have is that the workshop that's discussed in the order, we think that should come earlier than where it's been coming, I think, generally in the summer. I think maybe February, March, April at the latest, prior to the filing in December. That way the parties can give some guidance ahead of time before they're getting too deeply into the details of the IRP. I also think that there are various issues that we've talked about in our filing, in our comments, that could be addressed potentially, and the company could get a good idea of what it should be addressing in the IRP, subsequently streamlining it dramatically if we're not, looking at every possible issue an IRP can address. And that way, I think that would save a lot of time, and it would save a lot of costs to ratepayers. And so my suggestion is that, and this is really just to Delmarva, but my hope is that we address this earlier as a workshop, and if a second workshop's needed, then to do it later in the year.
Well, Ms. Scott was very close to you. I'm sure she heard what you had to say.
I wrote it down.
Okay. Thank you, Mr. Burkett.
You're welcome.
The commissioners have any questions of the parties?
Will we adopt order number 9101 as presented?
I second.
Any discussion on the motion to approve proposed order number 9101? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion carries. Thank you, everyone. Bruce represents MAREC.
Yes.
Number 4 is in the matter of the application of Delmarva Power and Light Company for approval of the 2017 program for the procurement of solar renewable energy credits. Ms. Scott.
Thank you, Chair Winslow. This is the final order with the specific findings and opinion of the commission in connection with this docket. As you will recall, you did approve the proposed program a number of months ago, and based on that, we ran the auction in June, but this is the actual final opinion with all of the parties' positions and discussion by the commission. I believe that Ms. Knotts may have a minor addendum to the form of order, in the SREC order.
Thank you, Ms. Scott. Mr. Willard?
Yes, as you said, we do have a bit of just a change in one line. I believe the commissioners have been given a new order with that change in it. On page 7, we talk about the different issues, and two of the issues that were not previously discussed. And the first is changing the monthly SREC payment obligation to quarterly or less frequently. On the next page, none of us caught this. We say the first issue recommended was implementing a program to pre-buy SRECs. That's not the case, so we've now changed that sentence to see that the first was that the changing the monthly payment obligations, and so we've made that change, and we believe the order as now written should be adopted. And Ms.
Madam
Knotts is here.
Secretary, Madam Secretary,
It's corrected here.
it's corrected.
But you didn't receive it because it just happened a couple minutes before you read it.
Okay, so any this document we're going to sign, that language should appear. We can double check it at that time.
It's okay. What paragraph? Second.
It's on page 8 of the order. It's
Number.
paragraph 18, pretty much right in the middle. Instead of saying DPA recommended implementing a program to pre-buy SRECs, we're going to say DPA recommended changing the monthly payment obligation.
Any further questions? Or?
Yeah, I have a question. This might be a question for Joe, Mr. DeLosa. Is that? I just had one quick question. I kept going back to this, and that is that are SRECs procured in denominations of 5,000? Because you mentioned that the increase from 15 to 20,000 is a result of the requirement that 1.5% of electrical energy sales be derived from solar voltaics, up from 1.25%. So I was trying to calculate that as a banker, and I saw that was a 20% increase, but the amount was being increased 33%. Is that because it's in fives, or why didn't it go from 15 to 18?
No, so I believe, and Ms. Scott can correct me if I'm wrong, the percentage change is due to the legislation. And then the Renewable Energy Task Force puts together a program with a recommended amount of SRECs for Delmarva to meet their renewable energy requirement. And so due to the recommendations of the Renewable Energy Task Force, when this program came before the Commission, that was the recommended amount of SRECs, and then the Commission approved that SREC procurement plan for the 20,000.
Correct. Yes.
So if your SREC requirements go up, there's not a direct correlation, is what you're saying. It went up
Correct.
this much,
Right.
this percent, but it doesn't mean that it's going to be direct. It's analyzed and determined that this would meet that requirement.
That's
It
correct.
happened to be 30%.
That's
Okay.
correct.
Thank you.
Ms. Iori?
No questions.
Thank you, Chair Winslow and Commissioners. The DPA has now confirmed that we do not have a problem with that proposed change. We appreciate being able to review the draft form of order when it was going through various iterations, and we appreciate both staff and Delmarva's and DENREC's, DENREC's, I don't want to say acquiescence, but we suggested some changes that with which they did not disagree, and those changes were incorporated into the form of order. And so the public advocate supports the form of order.
Thank you, Ms. Iori. Mr. Noyes? Thank you, Mr. Noyes. Commissioners, any questions?
I move we approve order number 9116 as adjusted, as corrected.
I second it.
Any discussion on the motion to approve the proposed order as amended? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries.
Thank you.
And number 5, in the matter of the application of West of Eastern Shore, LLC. Do we have Ms. Culver? How was the traffic for you?
Just as bad as it was for everyone else, but I caught Miss Iori in my rearview mirror, so I figured I was going to be okay. You did not, but you were staying right with me, so I knew that you...
So you were going 90 miles an hour as well.
Sometimes...
Gotta do what you gotta do.
Well, exactly right. I was just trying to stay ahead of you.
Want to see a policeman? Because I didn't.
No.
Yeah, they were guarding the construction site.
Yeah, oh, yeah.
Well, that was a good thing for some of us. Trying to get here.
Yeah. Good afternoon, Chairman Winslow, members of the Commission. This is the motion filed by Comcast of Eastern Shore, LLC, to extend certain of the deadlines set forth in Order 9092, which was entered by the Commission on July 25th, opening a docket regarding the renewal of Comcast of Eastern Shore's cable television franchise. That order set forth certain deadlines for the publication of public notice, filing proof thereof, and for intervention, and largely as a result of a miscommunication between my office and one of the newspapers, the Cape Gazette, that only publishes twice a week. That notice was not timely published. So we amended the order and sent that over to Mr. Walsh and also to Ms. Woodward, adjusting those deadlines so that the timely public notice could be provided and adjusting the date for intervention. As I was reviewing the order yesterday, I noted that there was a date in paragraph 6, which appears to be an optional deadline, but it was not clear to me whether an amended application would have to be filed by that deadline. So I did contact Mr. Walsh and Ms. Woodward yesterday and asked them to advance that date as well from September 15th to October 23rd, and provided them with an amended order. I don't know.
Okay, thank you very much, Ms. Culver. Mr. Walsh?
Thank you, Chair Winslow, Commissioners. Ms. Culver presented an accurate statement of what unfolded here. We did not want to make any unnecessary obstacles. We looked at the amendments, the dates shifted based on the publication having been missed. With this latest revision to paragraph 6, we thought that too was not prejudicial to any of the parties. I did circulate that to Ms. Iori yesterday as well to make sure that she was aware of it, although I don't believe DPA had any issues with this order in any event. So we respectfully request the Commission approve the order as submitted.
Thank you, Mr. Walsh. Ms. Iori?
Thank you, Chair Winslow. The public advocate supports the proposed form of order.
Thank you. Any questions, Commissioners?
Move we adopt order number 9001 as presented.
Second.
Any discussion on the motion? Great.
Mr. Chair, just one clarifying question. So as submitted, I see September 15, but
Mine
paragraph 6
there
is
was another one that
October
came out.
23rd. Okay, good. Thank you. No further questions, Mr. Chair.
All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion carries. Ms. Culver, is your speech in number 6 about the application of Comcast of Newcastle County the same speech?
It will be the same with a different docket number and different party, but same circumstances.
So we'll incorporate by reference your previous comments into this docket and ask Mr. Walsh if he has similar comments.
Same comments. We approve the amended order as revised, including paragraph 6, which I also circulated to Ms. Howard yesterday.
Ms. Iori?
The public advocate supports the proposed form of order in docket 17-0507.
Any commissioners have any questions?
Move we approve order number 9115 as amended.
Second?
Any discussion on the motion to approve proposed order number 9115 as amended? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Ms. Culver. I hope your trip back is much more calm.
I do as well.
And I'll keep Ms. Iori here for quite a while, so you don't have to. Sorry, she's going to keep herself here for a while. Thank you. Number 7, in the matter of Verizon LLC's USAC e-file certification of FCC motion to amend order certification of FCC Form 481. And Mr. Willard.
Yes, this is an annual thing that comes up. Mr. Howard has prepared a letter that the commissioners have received, and he'd like the authority to send out that letter certifying that everything's in order with this filing.
And we have a proposed letter from Mr. Howard on our desks. And for Bonnie Metz and Ms. Smith, Sherry Smith, who are out there in television land, we miss you all. Anybody? Okay, how about Ms. Iori? Do you have any comments to make?
We do not.
Any commissioners have any questions of Verizon, who's not here, or Mr. Willard, who knows all about this filing?
One clarifying question, Mr. Chair. In the end of the first sentence, it says a certification made on September 18. Is that September to be today, September 14, or is that certification only coming on the 18th?
Mr. Howard?
The letter calls September 18, and I'm just questioning whether it's being made a certification today or it's being made a certification 4 days from now.
It'll be certified as a result of this order not being signed today.
It can be made any time up to October 1st.
Okay, so it's irrelevant.
So it's
Yeah, got it.
Maybe tomorrow, could be the next day, but I'll wait till the 18th because that's what's in the letter.
Or you just put the 18th on the letter and mail it.
Mr. Chair, I recommend the Commission approve and accept the letter submitted by Mr. Howard.
I second it.
And also approving the order 9110.
Yes, and I further...
No, I apologize.
Just a letter.
I'm jumping ahead of myself. You're absolutely correct, Commissioner Gray.
Okay, so that's an adoption of the letter as submitted by Mr. Howard.
Right. And was that seconded?
You have a second by Mike, I think.
Okay, any discussion on the motion? All in favor signify by saying aye.
Aye.
Any opposed? Any abstention? The motion carries. Thank you, Mr. Willard. I guess I was trying to get ahead of myself, but number 8 is in the matter of the notification of the public utility requirements for electric and natural gas vehicle charging services. Commission to consider proposed order 9110. Mr. Walsh.
Thank you, Chair Winslow and Commissioners. This order number 9110 in docket 17-0933 memorializes the Commission's decision on August 8th. There's respect to the staff's August 2nd petition seeking approval to send notification to electric vehicle and natural gas vehicle facilities of the requirement as a public utility. The Commission at that hearing also heard from DENREC, and this order simply memorializes the decision, which was to delay any decision on the petition, but to approve DENREC's recommendation that DENREC, other parties, the staff, get together and consider submitting this for consideration at next legislative session in January, I believe. And we certainly agree with that, and we're glad it's on the table. And I don't know if anybody from Denrec is here, but.
Yes, there's right across the table.
Oh, okay.
Mr. Noyes.
He wasn't here for that, for this one, that's somebody else, but.
Well,
Thank you.
Chair, Denrec appreciates the Commission's responsiveness to our recommendation, and we are committed to working with the Commission and other parties to resolve this matter through the General Assembly. My lawyer got here.
My apologies for the delay. There was also a car fire on one after the fee tour.
I'm glad you got here. Mr. Walsh couldn't see Mr. Noyes.
I apologize. Apologies to Mr. Noyes. I associated with the young lady representing Denrec at the last hearing, and
True.
went there.
Joe, sir, would you like to make a comment?
Happy to be here.
That's okay.
Okay. I think I better leave it as it is. Ms. Iroy?
Thank you, Chair Winslow. The public advocate does not oppose the proposed form of order and hopes that it will be one of the interested parties that gets engaged with staff and Denrec and whoever else might be interested. Thank you.
Thank you, Ms. Iroy. Just speaking for myself, I'm glad to see that this is percolating. I also, you probably all know this, but Commissioner Gray has got the assignment of talking about electric vehicles at a MACRUC commissioners-only strategy meeting. So he's gotten together a lot of information for a lot of different states. So I'm sure he'll be advising us of what he's learned and teach us what he's learned at some time in the immediate future. Any commissioners have any questions about the proposed order?
We adopt order number 9110.
Any discussion on the proposed order? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstention? The motion carries. Thank you all. Number 9, in the matter of the application of Delaware Power and Light Company for approval of energy efficiency programs for electric customers and rate recovery mechanism. Mr. Goodman.
Good afternoon again, Chair, members of the Commission. You know, right before I came up here, I got a notice, a text of DelDOT. Apparently, a couple truckloads of live chickens have turned over on Route 1 and are now running around. It's a joke. So, yeah, everyone came up here, had something to report. I just thought. I was alone. So, what the Commission may remember that we were actually here and opened a docket on this. I wish I could recall the date, but it was maybe under a year ago because the legislation requires deferred accounting. And so you approved a regulatory asset, which I think it's very small right now, at well under $100,000. So this docket is actually open. So Delmarva's application is under an existing docket, and it is for approval of the energy efficiency programs that were developed in collaboration with and are being recommended to the Commission by the Energy Efficiency Advisory Council. And this is all pursuant to a legislation that now requires all utilities in Delaware, including the municipals and co-ops, to put together energy efficiency programs for their customers. So we have filed this. You will notice that we asked if we could try and move this along soon enough that we may be able to start these programs January 1. And your staff and DPA have been very cooperative there and agree that we should try to do that, and your staff put together an order that would hopefully enable that to be accomplished, because Delaware is, it seems like a lot of people want to get this done and start these programs. I'm pleased to say that if you notice on page 3 of the order, and it's in the second whereas clause on there, we have estimated actual charges to customers for the 3-year program being 23 cents in year 1, 64 cents in year 2 and $1.20 in year 3. I don't know if you're familiar with what's being paid in other jurisdictions, but I would say by year 3, it's still about 1/6 or 1/7 of what's being paid a few miles away in Maryland, and that's pretty much complements of the monies from DENREC in their programs, monies from RGGI that the SEU is using. So Delmarva has to do very limited work in this area compared to other jurisdictions, and therefore charges its customers much less. And that's, obviously I think a good thing. And the other thing you'll see that I think is important in this docket is that the Energy Efficiency Advisory Council is also recommending that whatever charges there are for this be shown on a line item, as we do with many other charges now. And I think that's very important to customers. They can see what charges are actually being incurred to deliver their power, what their power itself costs, and what other programs cost. I think that's very important for customers, and I think that's a nice change that happened about 2 years ago now with the bill. So with that, I want to thank cooperation from both DPA and staff in getting this order together.
Thank you, Mr. Goodman. Mr. Willard?
Yes, we agree with what Mr. Goodman has said. As he said, this is based on the recommendation of the Energy Efficiency Council. We think it's a valid thing. We asked the Commission to adopt Order 9112. He went over the costs involved, and I believe that they believe there's going to be benefits far exceeding the costs in this, and we recommend approval of the order.
Thank you, Mr. Willard. Ms. Iori?
Thank you, Chair Winslow. The public advocate supports the proposed form of order. We thank staff and Delmarva for their cooperation as we went through the drafting phase. I do just want to note 2 things. Mr. Goodman mentioned the regulatory asset. As you know, that's a burr under our saddle. But this is one about which we cannot fight because the legislature has decreed that Delmarva can defer the charges for these. So there is nothing about which to fight on our side. Secondly, with respect to funding, the legislature has also decreed that before putting this on to ratepayers, that other sources of funding be investigated, and the public advocate does intend to inquire into that during the course of this proceeding. So,
thank you, Ms.
thank
Iori.
Just one quick thing, and I want to thank Mr. Willard for bringing this up. I should have mentioned it. I talked about the cost of the program. As you'll recall from when this was opened originally, the statute mandates that the benefits to customers be outweighed, and the term uses that it be cost effective. So when we talk about a cost in year 1 of 23 cents to 64 cents in year 3, 120, the benefits are significantly higher than that. And if you don't agree with that and you don't find that, then you won't approve these programs, and you shouldn't. And with regard to other funding sources, they were carefully investigated by the EEAC. And so if that has to be looked into a second time, then we'll have to address that when it comes before you.
Thank you, Mr. Goodman. Any commissioners have any questions of the parties?
I move that we adopt order number 9112, opening the locker.
I second that.
Any discussion on the motion to approve proposed order 9112? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. Any opposed? Any abstentions? The motion carries. Thank you, Mr. Goodman.
Thank you.
Mr. Willard, Ms. Iori. Number 10. By the way, there should have been an S on the end of that word you used. Saddle. Number 10. In the matter of well, I think so. I'm sitting. The matter of the provision of standard offer supply to retail consumers in the service territory of Delmarva Power and Light Company. Ms. Scott.
Thank you, Chair Winslow and Commissioners. This is the annual order submitted to the Commission to approve changes to the RFP and the full service requirement agreement associated with the standard offer supply procurement process. In this particular instance, there were a couple of changes proposed, most significantly as a result of the order that was issued in docket 140283 that reviewed the SOS procurement process. We are transitioning to fixed price contracts for residential small commercial from 3-year to 2-year. So that is being addressed as part of this process. In addition to that, we have included some changes to the eligibility requirements so that an applicant who does not have a guarantor or a parent company with a credit rating would still be able to be eligible to participate so long as they provided a letter of credit or cash in the amount of $600,000. And the third proposal was to details about the bidding schedule. The dates obviously had changed in connection with this particular year. And then finally, in the full services agreement, we did delete provision that is simply something that has not been used in some time, which is the buyer downgrade event. I should also note that because this matter is on the agenda for this meeting as opposed to the September 28th meeting, which is when we thought we might be here, we also need to make one further change to the RFP in terms of the date of approval of this particular matter. So it would change from September 28th to September 14th.
The existing order's got to be changed to September 14th?
No, the RFP document that's part of the documentation that was attached to the order. No issues whatsoever with the form of order.
Mr. Willard.
Yes, a little bit of history here. Back in 2005, the Commission approved the RFP process to supply the wholesale market. 2008, you agreed that the wholesale suppliers would no longer have a duty to provide the RECs. In 2017, you approved the change from a 3-year contract to the 2-year contract, which Mr. Scott mentioned. And this document has a lot of exhibits and things. The staff has reviewed them and found no issues. And we recommend approval of order number 9113. And Ms. Knotts is here if there's any questions.
Thank you, Mr. Willard. Ms. Iori?
Thank you, Chair Winslow. The public advocate supports the proposed form of order.
Thank you, Ms. Iori. Commissioners, any questions?
Move we adopt order number 9113.
I second.
Is there any discussion on the motion to approve proposed order 9113? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thanks, Ms.
Thank
Scott. Please take home. That concludes our, Number 11. In the matter of the petition of Artesian Water Company for authority to establish a regulatory asset. Now, we've been kidding a little bit about this matter, but it's obviously a serious matter, and we've heard a lot, and we've received a lot of paperwork, but it looks like we're going to be receiving some more. Okay. What I propose on having Mr. Randall, Ms. Iori, and Mr. Walsh do is to provide us with, I don't think we have a dearth of time actually, so let's say everybody can have, let's really be generous and try to come way under this, but that 10 minutes be okay, Ms. Iori? I know you got part 1 and part 2, but that doesn't mean you get 10 and 10. But it seems like you put some things together to help out right here.
I guess I'm not sure how much you want to hear from us. At the end of the last meeting, you asked us to try to find out what other states do with respect to these.
Right.
And what I've just handed you is the results of my investigation as to the cases that I was able to find from my research. They were provided to Council for Staff and Council for our team on Monday. pursuant to your instructions at the last meeting. So I didn't know whether you wanted to hear all of our arguments all over again.
No. Please, all I would really wanted to get is sort of a synopsis of the neighboring states' utilities and what they've done. And I've had the opportunity to look at them, but to be perfectly candid with you, some of the cases are fairly long, and some cases, Ms. Iorga is kind enough to make a mark so I could sort of catch where the issue is being discussed in that particular order. So I think if you would maybe sort of...
Just want to make clear that I was not engaging in any ex parte communications with Chair Winslow on this. I was asked by Mr. Willard if I had copies of certain cases, and I provided those cases to Mr. Willard.
Oh, no, we've had no discussions whatsoever.
All right, well,
so let's start. Let's start with staff, since they were the ones that filed the motion. So, Mr. Walsh, you want to give us words of wisdom about what the surrounding states have done? And I say the surrounding states, I guess that includes Hawaii as well.
Thank you, Chair Winslow and Commissioners. Just a point of clarification. Are we keeping this to 10 minutes a party?
Yes.
Yes.
Okay.
Or less.
Okay, thank you. Then I will omit the chronology of events. I think everyone in the Commission is well aware of how we got here. And we did receive, as the Commission directed, the research from the various parties. This meaningful little stack here is from Artesian. This is the DPA's stack here. A lot of Hawaiian and Wyoming cases.
Texas, too.
And Texas. Reminds me of the Woody Allen line that he took the speed reading course, comprehension, read War and Peace in an hour. It's about Russia. I found nothing dispositive, influential whatsoever in any of these, and I did peruse through them.
I think you're talking about with respect to litigation under contribution and aid to construction, right? I mean, it really, to be frank with you, it was pretty informative. I mean, I found that the ideas expressed by the other commissioners were informative.
They were informative. I used, with all due respect, to borrow Ms. Iwor's word, they were not dispositive. What I believe is dispositive, and what we would ask the Commission is to look at, for example, this Commission's order, number 8556 in docket 13250, in which the Commission approved a regulatory asset to Delmarva for the recovery of costs reprogramming its billing systems. That cost was estimated to be $23,630. That cost, as with, was neither extraordinary nor financially harmful. Now, here, what we're asking the Commission to do is reconsider Artesian's regulatory asset request and use as a criteria not exclusive reliance on the establishment, but on the following expenses: extraordinary non-recovery expenses would jeopardize financial integrity. I'm sorry. The non-recovery of the expenses would jeopardize the financial integrity of the company. Non-recovery would financially impair the company's ability to provide safe and adequate utility service. This is not so much about the amount as the underlying policy. Before I get to the policy, I think it should be noted that what the Commission relied on December 20th, as submitted by the public advocate, did not include FASB, which is the Financial Accounting Standards Board 71, which does not require any financial
Mr.
instability.
Walsh, I apologize for interrupting, but we're not really discussing the motion to reopen. That's been granted, I believe.
This is further reconsideration.
Reconsideration, I apologize.
And the elements.
We really want to hear about the law with respect to regulatory assets.
Okay.
What law, what's the law, and especially with respect to the utilities that are our neighbors, basically.
Well, the utilities that are our neighbors have adopted FASB 71. That was part of my point there. This commission has, in several orders, and we provided those, taken a more flexible approach. And there is also Maryland Public Service Commission, 1993, and this was submitted to the parties, approved a deferral for Baltimore Gas and Electric and stated that it should consider all the equities as well as the regulatory efficiency in deciding whether to permit the deferral. What we are suggesting is that the equities, the fairness here cannot be constrained by strict guidelines which look at this net income and whether this amount is going to create some sort of financial instability. This is an extraordinary event. It was for the benefit of the ratepayers. Artesian and staff defended that case, and had they not and been victorious in it, that charge of over $500,000 would have gone into the rate-based case. It does not now. That is clearly a ratepayer benefit, and that's how this should be analyzed. That's the real policy here. They spent a few cents to win a quarter, let's say. That is significant to a ratepayer, and that is a policy that should be considered. They shouldn't be punished for fulfilling a fiduciary duty to the ratepayers, which is what they did. The Delaware Public Advocate has a statutory duty to represent those ratepayers too, but did not intervene in that case. That's extraordinary. They did intervene against the company when the company sought for a regulatory asset, not as a guarantee, but simply to include it, which would be subject to review in a rate-making case. That is the proper standard under which to view this regulatory asset request. And I'll reserve, I think I have a couple minutes here looking at my watch, for rebuttal, if I may.
No, you may not. We're going to hear from Ms. Iori, and that's going to be it. Want to say a few more words? No, I would to Mr. Randall. That way, Ms. Iori, you can have your time, and then we won't need to have any more discussion.
I note only that Mr. Randall didn't provide any cases from other jurisdictions, so I'm not sure what he can add to the discussion if that's what you wanted to hear.
Well, I think we should ask him and see what happens. He's got the information from you and from Mr. Walsh, so he may have some comments with respect to them. Mr. Randall?
Chair Winslow, actually, I was going to speak to the authorities that we found, which were Delaware authorities. If you would prefer that I not address them, I will have nothing to add to the conversation.
Yeah, I don't think, thank you very much, Mr. Randall. Ms. Iori?
Thank you, Chair Winslow and Commissioners. This is the docket that I thought that Jarndyce versus Jarndyce might apply to. This is the third time we are here before you, and hopefully it will be the last. I wasn't aware that we were supposed to confine our research to immediately surrounding states. I know staff didn't do that either. But let's talk about immediately surrounding jurisdictions. District of Columbia. The Commission may consider creating a regulatory asset for recovery of significant unexpected utility expenses incurred outside the normal course of business, particularly where expedited recovery is necessary to shore up the utility's financial situation. Yet the Commission has generally been cautious about granting regulatory asset treatment for utility expenses. When a regulatory asset is created, it strengthens a utility's claim that the expense was prudently incurred and that there is a reasonable assurance that the utility will be allowed to recover it in rates. The DC PSC said that in an order involving Pepco issued on July 10th, 2014. DC is a surrounding jurisdiction. Pennsylvania is also a surrounding jurisdiction. And Pennsylvania said this is what they look at. Are the expenses extraordinary, unanticipated, non-recurring, and substantial? If the expense is a routine business expense or foreseeable costs incurred for routine business operations, deferred accounting treatment will be denied. And that's a PPL case from 2014 and a Duquesne Light Company case from 2013. And I note that in that case, the Commission found that a $2.87 million expense did not satisfy the substantial requirement. Virginia is pretty close to us, and they say their standard is, are the costs non-recurring or unusual in nature? Are they beyond the utility's control? Would the utility's financial results be materially and negatively affected if they are currently expensed? That's from the Appalachian Power Company case in 2012. Now, we did provide other jurisdictions, and most of those jurisdictions will support what this commission held originally in United Water. Colorado, District of Columbia, Hawaii, Minnesota, Ohio have used words such as sparingly, exigent circumstances, cautious, and exceptional to describe when a regulatory asset should be approved. Colorado, D.C., Hawaii, Illinois, Massachusetts, Minnesota, Texas, Virginia, and Wisconsin have required a showing that denial of recovery would or could have an adverse effect on the utility's financial integrity. And I've also noted that FERC has a materiality standard, excuse my tongue-tied there, and that is, bear with me because I have my whole argument here and you don't want to hear most of it, so I will not go through most of it. But in any event, FERC's materiality standard is 5% of the utility's net income. Here we are talking about $177,000 that has already been written off. So don't think it meets the materiality standard. Mr. Walsh mentioned some Delaware cases. You said you didn't want to hear about them from Mr. Randall, so I will not go through them either unless the commission wants me to.
Well, you've given them, we've gotten them, so we've had a chance to read them, and some of us have experienced them as well, so I don't think that's necessary. I would comment that, I shouldn't have made a comment about the neighboring states. I didn't mean to limit you that way. Frankly, I thought the Hawaii case was really interesting about where they look at perhaps an offsetting decrease in expense. You have an extraordinary expense over here for something, and then you have a corresponding decrease in expense over here, so they're not going to award a regulatory asset. So I thought that was interesting as well.
They do say that, but you have to meet all four of those standards for those.
Correct.
So, and as with respect to FASB 71, this commission has acknowledged FASB 71 because that is the standard that for accounting purposes they can only book a regulatory asset if the commission finds that it is that there is a reasonable possibility or probability, that the expense will be recovered in a future rate case. So it is not that we ignored FASB 71. I thought we had addressed that previously. Unless the commissioners have any questions for me, that concludes my discussion of what other states have done.
Thank you, Ms. Iori. Any commissioners have any questions of Ms. Iori or Mr. Walsh or Mr. Randall? Well, I guess I'm probably the one to blame for this whole long, involved process, and to be frank with you, from the very beginning, I felt pretty strongly that the regulated utilities' interests have got to line up with and be compatible with the public interest. And I thought our decision initially did not do that, and I thought that was a fatal flaw. The utility should do and take actions in accordance with what the public interest is. And it's hard, as Mr. Walsh argues, to come up with some relatively short, concise 3 or 4 characteristics to cover every situation where a regulatory asset is requested and then perhaps approved. My viewpoint, and I would make a motion to put it on the table so that we can then ask questions under the motion. But I think that decisions on the application to set up a regulatory asset really should be made on a case-to-case basis. It's almost like, it's just hard to pigeonhole everything into some, because you can't anticipate. For example, when United Water came out, there wasn't a contribution in aid of, I don't believe there was at that point in time. I think SEAC came out afterwards, right? No, before? SEAC was before? But anyway, I guess as one of our Pulitzer Prize winners and songwriters said, that the times they are changes. So time does change. Things do happen. Unexpected things occur. Litigation occurs that you don't expect, and it's extraordinary. And then you find yourself in a situation like this where I believe the corporation should be incentivized, or at least be given the possibility of being made whole if they do something which is in the public interest, which I believe is what happened here. Also, if something happens by legislation, as Ms. already referred, or by federal or state commission ruling, or any other extraordinary circumstances, I can't anticipate what all those might be. So I think that's why it's got to be sort of on a case-by-case basis. Also, I think the Commission's ruling should be consistent with FASB, the Federal Accounting Board. And of course, we were talking about Rule 71 in this particular situation. I think the state made some good points through Ms. McDowell in its paragraph 25 of its October 20th, 2016 letter. And I also think that the ruling of the Commission would indicate that there's a probability of recovery, but it does not prejudice, it does not prejudge the appropriateness of cost recovery for the issue, because as that Hawaii case points out, there might be another factoid about the utility that would, for reasons of fairness and justice, would offset that cost by the utility, and so at a second hearing on whether or not, how much and how many years over which it might be paid, those issues have got to be addressed. So I'm in favor of indicating that setting up this regulatory asset primarily because I think all regulated utilities should do what's in the public interest, and for the other reasons I've stated. So that's my motion, that the order be consistent with what I said, perhaps what might be said in terms of additions to the order, or perhaps it'll be the way Ms. Iori states, and I'll be sitting in a single vote seat at the end of the day. Whatever happens, this will be over with, and everybody will be smiling at the end, regardless if they won or lost.
Well, we'll be smiling at Joda.
Well, that's correct. And see, I might not even get a second.
I will second that motion, and I will add that your reasoning goes along with my reasoning for ending the sentence in the prior one that says just change and doesn't delineate, because things do change, as you said.
Is there more discussion? Commissioner Gray.
So I guess I would start by indicating in this discussion, I've not really heard anything that would compel me to change my position from the initial vote. I understand from a business perspective and from an accounting perspective, the postings for the accounting purposes should be within the period where the costs and the revenues have been incurred. And if in future rate cases you have this outstanding expense, I don't believe you can reach back and compensate for it. But one of the drivers for my decision making before is I think that there's a balance in making sure that there's a sufficient amount of diligence not to either take on extraordinary legal expenses. Of course, they're going to benefit the ratepayers in this case. What would be ideal is if there was some ability to make the loser in litigation pay all legal expenses. Then, of course, the ratepayer would be protected if you were successful in winning the case, right? Or losing. If you were successful in winning the case, then the person who brought the litigation would be responsible to pay for everyone's legal expense. But also, in summary, as I looked on the numerics, it appeared as though your annual projection for legal expenses was $117,000, and the expense in this case was $177,000. So as I look at it, is a net $60,000 above what you had projected in legal expenses for the period. And a net 60 over your portfolio seems to me that cost savings in other areas could balance and negate that loss, and that the owners and the stockholders, the stakeholders, wouldn't really lose that much. Management would be able to absorb it. So absent any other compelling evidence and influence in today's hearing, I would be more inclined to keep my vote as a no.
Well, Commissioner Gray, the only retort I have to you is that obviously there is no provision in Delaware law for Artesia Woodard to recover the lawyer's expenses from the defendant in this particular case. Secondly, with respect to reporting about the expenses, that would be part of the second shoe dropping. In other words, we could let them have a regulatory asset to be considered, and then when we consider the facts, which are, as you stated, the amount of money in their annual budget, I mean, if they were given sufficient money in their legal budget, we wouldn't award them any recovery, or maybe we would reward them half of a recovery. But that's part of the second part of the analysis. The first part is whether or not this situation is such that a regulatory asset should be approved. It's got nothing to do with $170,000 or whatever the figure is, et cetera. It's okay. How about some more discussion? Let's have some more. Commissioner Correa.
Keeping an open mind and also remembering all the points staff has recommended or discussed last meeting, that consistently in all discussion we have heard that the expense or extraordinary expense, and it's a theory, that, and it can be 100,000 or 100 million, that has it affected the results of the utility negatively. So if you look in this particular case, the quarterly results ending December 31st, 2016, were not negatively affected as I saw it, unless you would give me other figures or give some other ideas. So the results were not negatively affected in terms of dividend, in terms of bonus to the chairman or the president, and or employees, or any other measurements or criteria you have to look at the effects on the operating results of the company. The stock prices certainly is a very good measurement. If a company spends $10 million and the stock prices go down and they don't have means to recover, then I would say, yeah, stock prices went down 20%, and it should be a regulatory asset and should be allowed to recover. So I'm hanging even with the open mind. My thinking is that PERC has a 5% rule. That was the only concrete figure came for the first time. Everything else was general. So general discussion is very good, but the PERC went ahead and put a figure that, okay, with the gross income or net income, if the expenses are 5% or more, they can be considered extraordinary or burdening to the results of the company and what have you. So I'm still, even being open-minded, I'm still not convinced that regularity asset can be created in this case, even though other states have both ways. I mean, we can interpret some of the states in different ways, but this is a specific case. Has the result affected any of the other measuring criteria, financial criteria? And my reading is of your balance sheet and K10 and whatever is not that. I didn't find anything like that as of December 31st, 2016 in K8, for example. So, and this 5% information is a very, very good. That is something specific rather than general. And therefore, my thinking is still the way it was last meeting, that it needs not to be created in this particular case because we want to go case by case. So in this particular case, I believe that it should not be allowed.
Anybody else have any further comments? Hearing none, all those in favor signify by saying aye. Aye.
Aye.
Aye.
All those opposed?
Opposed.
Anybody? No, there's no one left to abstain. The motion carries. Okay, we have a hearing scheduled for today. Thank you, everyone. Seriously, you did a lot of great work. Ms. Iori, very well done. Thank you, Mr. Randall, very much. Okay, the hearing schedule, there's nothing on the hearing schedule. Mr. Noiser, is there anything else that you'd like to make in sort of comments on behalf of DENREC?
Thank you, Chair Winslow. I was asked by at least one soul coming in here when the offshore wind working group would be meeting, and the answer is no meetings have been set. We're waiting for the final roster of members to come down from the governor's office, and then when that happens, we'll be setting meetings, and I'm sure all of you will be hearing from us, and in part because some of the folks in this room will be members of the working group. And then, so that's what I know at this point. I just wanted to add, on a personal note, my sadness at the passing of Arnetta McCrae. She was chair when I first started showing up at these commission meetings. She was open and rigorous and impatient at times when somebody would start offering nonsense in front of the commission. She was quite a character and set a great example of public service.
Thank you, Mr. Noyes.
Thank you.
Mr. Hallett.
Chairman Winslow, Commissioners, I appreciate the opportunity to address you again. I have a surprise presentation for you, which will probably take at least 2 seconds, from Ms. McDowell.
Surprise! The Delaware Public Service Commission is celebrating Lifeline Awareness Week this week. It goes from September the 11th through the 17th, so it's this week. And for those who are not sure what Lifeline is, it's the federal program that helps make telephone service affordable to people who are low income. It's now available through internet or broadband service, so that's a new addition this year. You can only have one discount, and it's either on your landline or you can get cell phone service. So what they do is they discount the landline down to about $5 or $6, and the internet service is usually a free cell phone. And we have a quote from our chairperson or chairman, and he said, "Affordable telephone and internet service is crucial in today's society
and the Lifeline program empowers many people who otherwise may be marginalized because of the cost of these services. I applaud all our ETCs, and Verizon is the largest one, along with, I think there's 3 cell phone or wireless. I can't remember all of them. Assurance, I think Verizon Wireless, and there's a second one or a third one. And for providing this valuable service to thousands of Delawareans. Thank you.
Thank you.
Chair Winslow.
Thank you, Ms. McDowell.
I couldn't have said it better.
Normally we have this wonderful proclamation from the governor's office, but we thought we'd shorten it a little bit this year because we've done that I don't know how many years in a row now, and I thought we'd just put notification out on our website so that people understand that it's Lifeline Awareness Week. So,
Thank you, Mr. Howitt. Just 1 second, please. Gloria needs to change paper.
We were very wordy today.
do you want me to go get a roll for you?
This is just back up again.
Thank you, Gloria. I will make note that our next commission meeting, in case anybody bails out because we're having such wonderful discussions here as the afternoon winds down, I will make note that our next commission meeting is on September the 28th. That is, again, a Thursday starting at 1 o'clock. I'm very pleased to have Mr. Joe DeLosa here today. We certainly want to keep the commission informed on all those wonderful filings that are going on behind the scenes, in particular with FERC. And Mr. DeLosa has been intimately involved with many of those, and I would ask him to give you a quick rundown of what's been going on there.
Good afternoon, Chair and Commissioners. So on your agenda, it says that I'm going to update you about 2 filings relative to Artificial Island. Since that time, we've actually made an additional filing, so it'll be 3. I'll try to be brief here. I believe you all know the background. This whole ordeal started on August 28th, 2015 with PJM's initial cost allocation filing for Artificial Island. Since that time, we've filed a complaint. We've had a technical conference. We've requested rehearing. We've been granted rehearing for further consideration. And that is where the posture stands. Prior to our most recent filing, Mr. Howitt last spoke to you in June about this issue, at which time he explained an April 12th PJM letter that noted that the application of this particular cost allocation methodology can result in cost allocations that seem anomalous. He also informed you of a paper issued the following day titled the PJM Alternatives Report, which, as you remember, has 2 different cost allocation alternatives with more beneficial results for the state of Delaware. Since that report has been issued, the Delmarva Zone parties, which is us, the Maryland PSC, the DPA, Maryland OPC, ODEC, Easton, and DMEC, have made 3 additional filings in 2 different dockets. So the first docket is ER 171420, which is PJM's newest 205 cost allocation filing after they paused the project, and then they restarted and made a filing in a new docket. In that docket, first we filed a protest on August 25th, essentially restating the arguments that we have been making in the first section of that filing, noting that solution-based defects as applied to the AI project does not produce costs that are commensurate with benefits, produces, in our view, an unjust and unreasonable cost allocation. And then that protest also included evidence from the PJM paper, which we said demonstrates that alternative defects methodologies exist to provide a more commensurate cost allocation. And as you'll recall, this is actually a question that FERC seek to address at the technical conference. One of their key questions was whether an ex-ante cost allocation method could be developed to better allocate the cost of a stability-driven project. So in that protest, I'll just give you a little bit about what we actually requested of the Commission. Our requested relief, first, is to reject PJM's filing under Section 205 as unjust and unreasonable. And then, secondly, was to require the PJM transmission owners who have jurisdiction over cost allocation to select and implement a new cost allocation methodology based on one or both of the alternatives identified in the PJM report. So in our filing, we did not choose one or the other of PJM's proposed methodologies. We instead stated that either or would be acceptable to us. Now, in that docket, that 17-14-20 docket, I'd just like to point out a couple other comments of note. Exelon filed in that docket in support of our contention that the cost allocation is unjust and unreasonable, which staff believes will have a fairly substantial impact on FERC's view of that situation. However, they did not ask the Commission to select one of PJM's alternatives, but rather proposed a hybrid of the existing solution-based defects with one of PJM's new proposals. So that's, having a transmission owner ask the Commission to find the existing cost allocation unjust and unreasonable. We do appreciate that. We're positioned still out relative to the hybrid, which is obviously not what we asked the Commission to find. LS Power also filed supporting comments relative to our asking the Commission to find the cost allocation unjust and unreasonable. And then Public Service Electric and Gas filed in support of the status quo. They said that solution-based defects was correctly applied to the situation. In their view, they stated that Delaware and Maryland customers will see benefits. And this brings me to the second thing that the Commission filed in this 17-14-20 docket, which was a reply to PSE&G. And essentially, with aid from our consultant, John Marcheski, we pointed out that a lot of PSEG's characterizations of the artificial island project were oversimplifications relative to some of the specific benefits that would be received, as well as mischaracterization as to the drivers of the project, which we felt needed to be corrected. There's also a couple legal arguments in there, but I won't bore you with that. And then the last filing that we made in this matter is a motion to reopen the record and lodge PJM's reports into our pre-existing and pending dockets before the Commission. So in addition to this new 17-14-20 docket, we also have 3 other artificial island dockets pending before the Commission. The original 205 filing from August 28th of 2015 That docket is still pending, as well as our original complaint under Section 206. That's EL 1595, and that docket is also pending rehearing right now. So what we asked the commission to do is to reopen the record in both of those cases, to add PJM's new analysis, which obviously shows an alternative, what we feel is a just and reasonable cost allocation alternative, as well as their discussion regarding the fact that solution-based defects may produce anomalous results, and PJM's thoughts on that matter. So those are the three filings that we've made in the artificial island-related dockets recently. And on that note, I'd be more than happy to answer any questions that you may have.
Joe, thank you so much for a really comprehensive and good picture of what's going on at the FERC litigation. I appreciate that. I would just like to comment and say that I find that the leadership at Exelon has showed a lot of courage and just great leadership ability. They've got constituents in New Jersey. They've got constituents in Pennsylvania who are going to be adversely affected, hopefully, by what the decision is at FERC. And so I think it really shows a realization that what's happening to Delaware is, in fact, unjust and unreasonable, and that they have the guts to stand up and say that in public and to follow through by a filing at FERC is, I think, highly commendable. And I would like to express my appreciation to them, and probably no less to also LS Power for their support in which I believe is a pretty pure and simple case of injustice as far as the cost-benefit of the present situation is concerned. Commissioners, any questions of Mr. DeLoso?
I have one question, and that is, in your opinion, what are the odds that the stability interface defects method of cost allocation will be used?
Well, Commissioner Drexler, when you ask opinions, it starts getting whether I can tell the future. The best answer I can give you is we have two brand new FERC commissioners. The FERC commissioner that remains is the one that actually published a dissent in the rehearing order in our favor. So in the old three commissioners commission, it was the commissioner who remained, Commissioner LaFleur, voted with us, and the two other commissioners voted against us. So in that respect, we probably have a better shot now than we did before. It would be pretty cool, for lack of a better term, if they pick that. I think FERC, and it's hard to tell the future. As the chairman stated, I think it is a pretty clear case of the cost not being commensurate with the benefits. I would also agree that having a transmission owner and the transmission developer come in on our side is likely to make our case stronger in that regard. That having been said, having the FERC just pick up one of these cost allocation methodologies, my bet is that it will be somewhere in the middle. If they find that it's unjust and unreasonable, as much as we would like for PJM's methodologies and for either or, as I stated, of PJM's methodologies to come to pass, and we will keep working towards that just and reasonable end, I'm not sure the Commission will go there right away. But we basically have no information on the voting history or position of the two new commissioners. So it really is up in the air.
Thank you.
Mr. Gray.
Yes, thank you very much for that presentation. I appreciate it. The good news, I think, is that at least one of the new FERC commissioners, I think, is aware enough about the problem statement that I think you've presented to FERC. So that's a good thing. At least they understand it. Do you have any sense as to their schedule in terms of the next key steps?
No. So as you're familiar, FERC has been without a quorum for quite some time. During that time, they've acquired quite a backlog of cases. There's more than a few that we are waiting on FERC action, for further guidance. This docket in particular is in a rehearing for further consideration stage, which means there is no deadline. The one thing I would add is that in all of our pleadings, we have implored the Commission to act for administrative certainty and ease of the participants, to act in a coordinated fashion on all the artificial island dockets. So I believe the FERC will likely do that. So once they rule on one, they will likely rule on all of the artificial island dockets. As far as when, I really have nothing to offer on that.
Thank you.
I would just point out that two of the former commissioners who ruled against us were former state commissioners, so I don't know that the fact that they are familiar with or understand it necessarily means that they're going to see the facts as vividly as I see them.
Thank you, Chair and Commissioners.
Mr. DeLosa, thank you very much. I appreciate you keeping up on this and participating on all those wonderful calls. We'll probably have to hire 5 more people just to support you in this effort, but we'll work on that.
My pleasure.
In response to one of your questions, Commissioner Gray, I do know that the FERC is planning on holding its first open meeting on September 20th. Now, that doesn't tell me what's going to be on the agenda, but I understand they have their quorum and they are now beginning to move forward. So that's a good sign.
Yeah, thank you.
If I may also ask Mr. Farber to come forward. Mr. Farber has been following some other FERC issues going on out there. He really loves to get into formula rates and rates of return and all those wonderful things, and he's been involved in definitely some settlement discussions, and I think he would like to share some of that with you, and at which point you may have to go into executive session for legal strategy. Mr. Farber?
Thank you, Mr. Howitt. Chairman Winslow, Commissioners, good afternoon. As Mr. Howitt described, this agenda item is to consider the results of settlement negotiations in FERC docket ER 17-419, which was a filing by TransSource Maryland and TransSource Pennsylvania, which I'll refer to as either the company or TransSource. In this filing, they were seeking FERC approval of their formula rate to recover costs associated with a market efficiency project that was approved by PJM, known as the 9A.
Known as, I'm sorry?
The 9A. Right. So I guess I would be somewhat remiss if I didn't point out to the Commission on December 1st, I provided a rather detailed presentation to the Commission regarding PJM issues. Including in there were my concerns with market efficiency, and in the interest of time, I won't repeat those concerns. However, I'm sure Mr. Howitt can provide those presentations to the Commission if you would like to have more insight into the issues with market efficiency. I guess I would note that my concerns with market efficiency have only increased since that December presentation. So in this docket, the company filed for approval of a 10.4% base return on equity. They were seeking approval of construction work in progress, as well as a 50 basis point incentive return for participating in the Regional Transmission Organization, or RTO, as well as an additional 50 basis point incentive rate for what they considered the risk associated with the 9A project. The Commission did not approve the incentive ROE at 50 basis points for the risk of the project, but they did approve the 50 basis points for the RTO. The only matter that they set for hearing was the base return on equity. So as a result of that, there were a number of settlement negotiations. There's a number of facts that are in public record that I could go over at this time. Time permitting, if you have questions. Otherwise, I would request that we enter into executive session so that I can discuss with the Commission those settlement negotiations that were held pursuant to confidentiality
in compliance with FERC rules, as well as potential future litigation strategy.
I move pursuant to 29 Delaware Code, Section 10004, subsection D, subsection 4, that this commission go to executive session to discuss possible settlement negotiations.
I second.
Any discussion? All in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries.